good morning and welcome to yet another edition of Government in Transition, a special program brought to you by the People's Progressive Party Civic. I am Michael Gordon. I'm joined this morning first by attorney at law Sonia Parag and Mr. Joseph Hamilton, we all know, veteran politician. I welcome you both to the program this morning.
Good morning, Michael.
Good morning. Good morning, viewers. Good morning, Sonia, my dear.
Good morning, Mr. Hamilton. Good morning to all the viewers.
Okay, I'm going to get straight. I'm going to cut to the chase, Sonia, being the legal mind on the program. And of course, we're fresh on the heels of a ruling of the Caribbean Court of Justice, which in essence reversed what we knew all the while, the decisions of the Court of Appeal, first on its jurisdiction, and also the interpretation of the ruling of the Court of Appeal by the Chief Elections Officer, Mr. Keith Lowenfield, in relation to him using that as a conduit through which he sought to disenfranchise 115,000 people. The thing is, Sonia, the APNU-AFC continues to see and again, a vulgar interpretation of the CCJ's ruling. And it takes me back to the APNU-AFC in opposition. When the budget for the Government Information Agency, for example, was cut to $1 by the one-seat majority in the joint opposition. Mr. Grange's interpretation of, or his reason for providing leadership for the cutting of the GINA budget was that GINA was not balanced. Is it part of the and parcel of the political DNA of the PNC to exercise at selective times willful ignorance?
I do believe that it is really, you and I had a conversation prior to the program being aired, and you were saying, and I do agree with you, that what they're doing, what they're expressing is willful ignorance to their supporters. And it is really a deliberate attempt again to mislead their supporters into believing that the entire world is wrong, the court is wrong, the international community is wrong, and just these handful of persons are right. We have seen so many times their blatant disregard and disrespect for the rule of law. And we've seen it so many times coming from orders that were made or decisions that were made by the Caribbean Court of Justice. So while I'm not surprised, I'm not surprised at all at Mr. Grange's statement yesterday to his supporters, I think they're running out of strategies, quite frankly, and there's not much left for them to say but to go down the path that they've always gone down, just to keep some sort of consistency with their craziness. But legally, this is what the Court of Appeal, this is what Lowenfield had sought to do. He used the Court of Appeal's decision to, as a legal, he wanted a legal means to commit an illegal act, as far as I see it. So what they did, they took it to court by a private citizen. The court ruled, and he went ahead and relied on that to produce his report to the commission. Now, the Caribbean Court of Justice, the entire nation sat at the edges of their seats yesterday, waiting to hear the outcome of the Mohammed Irfan Ali and Bar Jagdeo against Eslin David matter. Now, the Court of Appeal, in its assessment of the matter, stated that, look, if the Court of Appeal rightly had jurisdiction, then the decision of the court would be final. There would be no appeal to the CCJ. The CCJ will not have the jurisdiction to hear it. But since you have gone and exercised a jurisdiction that you did not have under Article 177(4), and it was unnecessary to interpret Article 177(2) because it was so clear, there was no ambiguity, and there was nothing to interpret. You had no jurisdiction to interpret. and you had no jurisdiction to insert a word or the word valid. Based on that exercise of a jurisdiction that they did not have, it opened the window for the Court of Appeal to grant special leave to the applicants or the appellants to hear their appeal. And that is exactly what they did, because the first order they granted was special leave for the applicants, for the appellant's matter to be heard by the court. So they assumed jurisdiction. They also ruled, setting aside or reversing, as you would have said, the Court of Appeal's decision in the Eslin David matter, stating that the court had no jurisdiction. And similarly, and that it was of no effect. And similarly, they invalidated the report produced by Lowenfield on the 23rd of June, 2020, as he relied on the Court of Appeal decision to produce that falsified report. Now, we are now hearing, the court was quite clear. There is no ambiguity in what the court has said. There is no room in what the court has said. There is no room left for you to misinterpret, for you to misguide your supporters as to what the position is. The court is very clear that when we are finished here, GCOM has to instruct the CEO to act in accordance with the law. Now, that was already done, as far as I'm seeing from GCOM, by their letter dated the 16th of June. That letter was quite clear, and if you'll permit me, Michael, that letter stated, pursuant to Article 177(2)(b) of the Constitution and Section 96 of the Representation of the People Act, Chapter 103, you are hereby requested to prepare and submit your report by 1300 hours on the 18th of June, 2020, using the results of the recount for consideration by the Commission. Now, that letter is quite clear as to the course or the path that the CEO has to follow. And it has the law set out at which you have to, the laws that you have to act in accordance with. So there is no ambiguity with that letter. When the Court of Appeal said you have to act, when the Caribbean Court of Justice said that you have to act, GCOM must now instruct him to act according to the laws. They have already done so on the 16th. And it is pursuant to Article 177(2)(b), pursuant to Section 96 of the RPA, and as per the valid votes and certified valid votes cast in accordance with the recount process. So that is all it is.
Yeah, I want to bring in Joe here, because Joe, this is a very, and in my view, a second landmark case tried at the Caribbean Court of Justice, which in essence reverses a decision of the Guyana Court of Appeal. I don't want to ask the question, what does that mean about the Court of Appeal in Guyana? But as it relates to the jurisprudence locally, it does not augur well, does it?
Michael, in the Court of Appeal, the CCJ pronouncement yesterday, if you recall, they referred to the no confidence motion case in passing and made the point that, the Guyana is without a parliament for over a year. Well, basically, in my view, what they were doing is to say that, a case came here where you had Court of Appeal judges trying to insert another word. You remember at that time, the word they were trying to insert in the Constitution was absolute. And the same thing they attempted to do here again. And we know that one of the judges at least were involved in both of these matters. I am of the view that you have some judges on the benches who wants to be politicians. You know, you can be a lawyer and be a politician. You know, Sonia is an attorney of law, and she has ventured into politics. That is allowed. But you cannot be a judge and a politician. That is not allowed. And therefore, you cannot make decisions as a judge based on your partisan political persuasion. And that is what has happened in both cases, in my view. For that matter, 3 cases, because we also had the appointment of Partisan. Also, they ruled that Granger could have done what he did. And so that is what, but this matter here, in my view, as a layman, I believe, and I'm alleging, there was conspiracy by these judges, the APNU cabal and Lowenfield, because nothing was coincidental. Lowenfield was to present his report by the 18th. Lowenfield sought to delay the report presentation. The same time Lowenfield is about to present his report, he is sitting in his office, waiting to receive from the marshal these brief that was filed with the court, and therefore acting upon that to say to GCOM that I am restrained when there was nothing restraining him to present his report. And therefore, everything was set in play. And the CCJ alluded to the fact. They didn't say, I'm saying it's a conspiracy. That the Court of Appeal, I forgot the word they used, but basically what they're saying, the Court of Appeal, by their decision, tacitly gave approval to Lowenfield to falsify this report and to discard votes, over 100,000 votes. So they opened the door, and that was not coincidental. That was deliberate, and that is the reason why this matter went straight to the Court of Appeal, because beforehand, APNU and their lawyers, they knew that they would have gotten a majority judgment because at least 2 of the lawyers, 2 of the judges there would have voted a certain way. What in all of this, Michael, when we look askance at the judiciary, at the Court of Appeal, we as Guyanese can feel proud of one Justice Rishi Prasad, that in all the instances, he went down the right track, utilizing the law and the precepts of the law to guide him. And he did not, he wasn't at all swayed by any political partisan position. I hope that these other people, they learn from Justice Rishi Prasad. Incidentally, the family is my country people from Triumph Village, Michael. I'm bringing up Rishi Prasad, whose father is a Triumphian like me, Prem Prasad, and the other brother, who are lawyers. But so, I believe that even with this that has happened, any such cases or that go to the appeal court before the judges of the like of Brassington and Gregory and the Chancellor Cummings Edward, they will rule the same way. Because in my view, they're shameless. They wear their partisan political tag on their back and on their shoulders. And that is what they continue to do. And it's a shame that, but think about it. And for young people, think about it if you didn't have the CCJ. Because remember, in the period of PNC in government for 28 years, at least part of it, you had no third court, because Burnham, I think 1970, removed Guyana when we became Republican status, I think, removed Guyana from the Privy Council. And therefore what you had is a compromise Court of Appeal at that time, flying not just the Guyana flag on it, but also the People's National Congress party flag. Because Burnham position and the PNC position was the party is paramount to everything. The judiciary, the legislature, and all the other organs of state. These judges are attempting to enable Granger in 2020 or in this period to fly the flag again, figuratively. So it's a good thing that we have, and it's again compliments to Barra Jagdeo, seeing beyond 2004 that he ratified as president the CCJ becoming the final court for Guyana. Let us think of, just cast your mind, what would have happened and what happened during the period when the Court of Appeal was subservient to the People's National Congress. But again, like the mistake they made with seeking to rig an elections in the age of technology, they're attempting at the level of the judiciary the same strategy that is 1970s and 1980s old, not recognizing the world has moved on, not recognizing that they cannot intimidate the judges of the CCJ. They are credible enough, they're strong enough, because they're not there to give judgment based on partisan political positions. They're there to interpret the law and rule in a way that speaks to the issue of human rights, speaks to the issue of us developing and strengthening our democratic culture in the Caribbean region. And that is how they continue to view these matters.
I want to bring us back to, of course, we are dealing with the issue at hand, but I just want to bring us back to the subject matter. Okay, the Caribbean Court of Justice has set aside the fraudulent report by Keith Lowenfield. That's the second fraudulent report by Lowenfield, the fourth between him and
Mingo.
The issue of the conclusion of the elections is now back in the hands of the Guyana Elections Commission, and the declaration must be guided by the law. I'm going to begin with you.
Some of them, Michael and Sonia, you know, some of them were saying yesterday that the fact that the CCJ now throw away Lowenfield report, GCOM can go back to Mingo report. I mean, the lunacy of all of this. You know, they were saying not so long ago, Granger, also that they're relying on Lowenfield report, and Lowenfield was the alpha and omega. So now Lowenfield report is thrown in the waste paper basket. They're saying, you know, we could go back to Mingo fraud. So you see the lunacy that is developing every day. The fact is, Michael, and I have always, I mean, what the CCJ did is strengthen the political position and the legal position. But there was no doubt that GCOM could have only ruled, declare rather, based on the recount results. And Sonia mentioned, and she read the letter that was sent to Lowenfield by the chairperson, that the report you're to present was in keeping with the recount tabulation. And importantly, Lowenfield already submitted the report as regards the numbers of valid votes, 460,000. And Tweet PPP got 233,000 and more, and APNU got 270. So that report, utilizing the 10 districts tabulation, signed on to by the, what you call the district coordinators, who was akin to the registration office of the district, already submitted it. This final report specifically has to do with the extrapolation of the numbers to say to GCOM, based on the report I submitted to you, utilizing the 10 district numbers and the total that I have added up. These are the allocation of seats for parties and for parties in the National Assembly and parties in the Regional Democratic Council. That is what this final report is about. We already know what the report is.
So, Sonia, we anticipate the conclusion of the election.
Yes.
4 months plus later, the conclusion of the election.
Yes, you see, when you say it like that, it sounds most ridiculous, because never in the history of Guyana, the region, the world over, we had an elections that lasted this long, and the level of lunacy, as Joe mentioned earlier, it continues every day. But I want to say this in relation to, well, the CCJ has ruled, and I'm most grateful for their ruling, obviously, and as the majority of Guyanese are, because it really does preserve the paramountcy of our court. Let me just mention in a short sentence that I agree with all of what Mr. Hamilton has said, but I want to add that the Court of Appeal of Guyana must maintain a separation of powers. It must maintain its independence, free from political interference and political persuasion at all times. Otherwise, we will never, and they've already damaged their reputation going down the line. We will never have an impartial court. So that aside, we are coming to the final days of the election, to a conclusion. And though Lowenfield, and I also agree that he would have presented in terms of his numbers, the correct numbers as reflected by the recount process and the elections on polling day, the counting of the ballots on polling day. So I don't see a difficulty there. Now, when he wants to import all of his opinions from the observations, that is rightfully for Article 163. That is rightfully for an elections petition. Article 162(1)(b) allows the commission, if Lowenfield decides that he's going to go again and come back with a falsified report, or continue to say that he has acted within the confines of the law when he has presented this falsified report. Article 162(1)(b) allows the commission, and it says this, that the election commission shall issue such instructions and take such action as appear to it necessary or expedient to ensure impartiality, fairness, and compliance with the provisions of this Constitution, or of any act of Parliament on the part of persons exercising powers or performing duties connected with or relating to the matters aforesaid. This is that the administration or the conduct of elections. So at the end of the day, the commission has a wide power. It has wide powers to not only instruct Lowenfield to act in accordance with the law, which they've already done, but to take the matter into their own hands and say, look, we've already had a number from you. We are going to make the declaration based on these numbers, which is the valid recount numbers. So Article 162(1)(b) allows the commission to bring finality to the elections process. And Lowenfield is relying on Article 177 when he says, look, the commission can only act on my advice. I've said this before and I'm going to say it again. When it says that you have to act on advice, it does not mean something that is illegal or perverse. So when you bring your report and says act on my report, it does not mean that you must act on illegal information or something concocted by you that is not within the confines of the law. So again, I will say that the commission and the CCJ has made it clear that GCOM has to instruct Lowenfield to act in accordance with the law in producing his report for us to have finality to the elections. If that fails, the commission can act on their own.
Sonia, we're practically out of time, but I want to raise this issue with you. You've seen in many quarters coming out of the APNU-AFC camp especially, deliberately skewing the decision of the Caribbean Court of Justice. One of the arguments that the APNU-AFC has been making is that the CCJ, in essence, and through its ruling, they have, more, for want of a better word, invalidated the recount exercise. I mean, how far into the realm of the ridiculous do we?
It couldn't be farther from the truth. It could not be farther from the truth. But then again, we're not surprised by them coming out and say anything that comes, any irrational thing that comes out of their mouths. We have all heard the ruling. Most of Guyana has heard the ruling of the Caribbean Court of Justice. And as I said before, there is no room for misunderstanding what they have said. They have not gone against the recount. They were simply ruling on the jurisdiction, or whether or not the Court of Appeal had jurisdiction, and thereby giving them the jurisdiction to hear the matter. They were also going into the realm of, since the Court of Appeal took jurisdiction and gave a lengthy decision that allowed Lowenfield to do what they invite him to do, commit an unlawful act. They now had the right, since they assumed the jurisdiction, to reverse that act. So it has not, there was nothing in there that invalidated the recounting. There was nothing in their decision, in their assessment, in their consideration that stated that they were invalidating the recount process, or even indicating that that was what they were doing.
Joe, I'm going to bring you in on this final point.
I mean, quickly, the thing is lunacy, because I am not a lawyer and I don't pretend to be one. This judgment coming out from the court was as simple as can be for a layman to follow, for ordinary people to follow. And they were pellucid that GCOM must instruct Lowenfield to act and to submit a report based on the recount tabulation. So you have to be a fool to hear that coming out of the mouth of the president of the court, and you're saying now that the CCJ invalidated the recount report. I mean, you have to be foolish, or think people foolish to accept that. They were attempting, by their machinations with the Court of Appeal, to have Lowenfield invalidate votes. The CCJ has pulled that back and has thrown that report with invalidated votes into the waste paper basket, and has ruled, thrown out the window the ruling that came out of the Court of Appeal. And importantly, the point Sonia made, the court could have only ruled on the matter that was before him, and that is what they did. They indicated, because there were some arguments put forward by Senior Counsel Ralph Ramker, and if you recall, and the court president referred to that there were some passionate pleadings. But it is not for this court to go down that route. We are dealing with a matter that was before us, and we have so ruled. And that is what they did. But these people will continue to misguide and fool their supporters, who are at the place where they want to be fooled. Because many of them know better and they should know better. And many of these people who are speaking, attempting to fool the people, they know better. But they're trying to utilize law to fight politics. And every time they're failing. So our expectation is GCOM would make a declaration based on the recount results, and once and for all bring this to an end. The declaration that Irfan Ali and the People's Progressive Party Civic won the March 2nd, 2020 elections. That is the only declaration that can be. The train has already left the station. It cannot reverse. It can only go forward to conclude the elections of March 2nd.
Joseph Hamilton and Sonia Parag, thank you both for being a part of the program.
Thank you, Michael, for having us.
Talk to you again.
You all have a good day. Viewers also.
Take care, Mr. Hamilton. Bye.
Okay,
And I thank you, viewers and listeners, for joining this program. This has been Government in Transition, a special program brought to you by the People's Progressive Party Civic. I'm Michael Gordon. Join my colleague Edward Lane at 1 p.m. as this program continues to update and inform.